Hey, Brian Parker here with another exciting video. I always say nothing better than a party, even a third party practice, that is. Today we're going to be talking about a concept I haven't touched on before that I, over the weekend, relied upon to do some fun things against a velocity plaintiff case. Again, as you know, I always do, or try to do most of my videos based on real cases that I have litigated or am litigating. That was my demand when I was in law school, that I try to get as many professors that are actually lawyers rather than professors. And that to me is the best way to teach stuff I'm already doing. So you can adapt, hopefully, your states and rules and regulations to the skeleton I provide you in the form of the video instructions and all the video and all the word templates that our membership website gives you. Been a tough week, got a cold. Oh, look at that. Anyway, this is another exciting video. Again, third-party practice to win debt collection lawsuits. Again, as always, please love, like, and subscribe. We're really getting a lot of subscribers now that stick around and enjoy at least the free aspect of our videos. And we also find that a lot of subscribers end up being subscribers to our membership website, which gives you like 250 videos and all the associated forms and documents. So that's the membership website. It's collectionstoppersolutions.com. Anyway, most states have similar third-party rules as far as litigation is concerned. So what do I mean by that? Anytime you get a lawsuit against you, you know, as I preach, you go look for the linchpin. Where's the weakness in the lawsuit? That ends up in your counter affidavit showing the court the problems with the lawsuit initially, and that'll follow you all the way through your litigation depending on what comes at you. And that's a defensive posture somewhat. It's also an offensive posture, meaning not offending anybody. I'm going on the offensive when I file a counterclaim. So that's a good approach towards bringing the truth out, settling cases quickly. But I find with especially velocity debt buyer cases, you say, look, this is clearly a problem here. You don't have the chain of title. No, I'll go, well, and they'll say, well, that's not our problem. Upstart created all these documents. So you've seen a lot of velocity cases that I've done, videos. The genesis of all that is Upstart Network Inc. that securitized the debt and then send it to all these tranches, and somehow it ends up in Velocity's doorstep suing my clients. So I'm always looking for new ways to beat them and win the case for my client. So I did a third-party complaint against the people that brought the debt to Velocity, which is Upstart Network Inc. So we're going to take a look at third-party practice. Anytime you receive a lawsuit, a defendant may sue a third party in the action who they believe is liable. And sometimes they're 100% liable, and that brings it out to the court that the plaintiff's claim doesn't have much to stand on. And even if it did, this guy caused all the problems and not me. And that works in debt collection defense lawsuits. So we remember to file our third-party complaint within a certain amount of time from your answer. In Michigan, let's put up Florida's rule, Shazam. Third-party practice, when available, anytime after the commencement of the action, a defendant may have a summons and complaint served on a person not a party to the action. So a third party is exactly what it sounds like. A third party, that guy, he's not part of the action. So we're going to bring a third party in to show that I'm not liable, or he or she doesn't have a claim against me. It's that guy, the third party. So you can bring a third party in the action. In Florida, you got to do it within a defendant need not obtain leave of court. What that means is a lot of times you do something within litigation, you have to ask permission from the court. But you don't have to do that. In Florida, if you do it 20 days after the defendant serves the original answer, you serving the original answer. So in Michigan, where I also practice, when defendant may bring in a third party. Anytime after the commencement of the action, a defending party is a third party may serve a summons or complaint on a party not a party to the action within 21 days. That's up there, Cindy, I hope, Shazamsky. My point being is these rules are pretty much all the same statewide. Just be cognizant of this one thing. Bring it or lose it, or at least lose the right to do it without permission of the court. That's a whole couple of months trying to get something done if you go through court these days. So the rules in most states give you the right to file this thing to start third-party practice without permission of the court if you do it early. You are suing someone who is responsible for suing you, but they're not on the caption, meaning velocity versus debtor. That neither the velocity you're saying is is suing you, but the real bad guy here is not on the caption. So by doing a third-party action, you bring in new guys to the caption, and I'll show you in a little while what that looks like. You do it because it gets the liability out of your hands, and the truth comes out, and eliminates the plaintiff not having to prove its case. Courts, I'd like to believe that in a perfect world, courts are neutral, but the fact of the matter is, whether it's by legislation telling a court you have to get all your cases done in a year, or a judge who just doesn't want to do the work, I see that all the time, or somebody has an agenda. It is not fair to you to face a summary disposition that a lot of my clients do, and the court, and I just did it on Friday, I presented ironclad proof why my client wasn't liable. Judge looks over at the attorney and says, "Is that true?" And she says, "No." And she went into some soliloquy about that had nothing to do with the case. Judge is like, "Well, okay, case for these guys," right? And I'm gonna have to appeal that. I'm gonna appeal it. I don't put up with that. And all I want to do is have the judge do their job. But they didn't mention anything I said and relied on just superfluous nonsense. The gig was in, I think, because judges want this nonsense off their docket because the legislature's breathing down their neck, so they'll find any excuse to kick your case. The reason I'm going into that is this kind of stops that. Because now there's more than one liable party in this. Now you've got a bunch of people. And also, when you bring in that third-party complaint, the velocity and upstart are now pointing fingers. They can't stay on the same side because they're already propping up something that doesn't have a foundation. Now you bring in upstart or a third party, they're a defendant now. You can do a summary disposition against them. And what's good for the goose is good for the gander. Court's going to favor your summary disposition if they're so inclined. So bring out the truth. Sometimes you got to bring in a third party. So that's what third party litigation is used for. Again, my client was sued by Velocity. So I filed an answer. I filed a counterclaim after finding the linchpin of their lawsuit to be no proof of ownership. There was such a big gap. But it gets to be where I'm like, I know I'm right, but courts. So I'm forever finding another way to have the court, make it impossible for the court to go the wrong way. So this third party action was filed on top of the counterclaim and answer with that counter affidavit. That counter affidavit follows you all the way through, right? So on my membership site, you will see my answer, my affirmative defenses, my counterclaim, and also the third party complaint. I'll throw in the counter affidavit too for you to use. I've got plenty on there. See all of my videos on creating the perfect counter affidavit and how to defend against collection lawsuits. Here they all are. Which way we're going to send them today? That way. So we have on our video membership site some good templates to go forward with the third party complaint. In this case, here, Cindy put up the bill of sale, Shazam. So that's a normal bill of sale that you see with the missing gap. Cindy emphasized Wilmington Savings Bank Savings Fund Society, Shazam. So that's Wilmington Savings Fund Society, FSB, as trustee of Alternative Lending Holdings Trust 2 as initial seller, is selling receivable and loans to Velocity on October 25th. And then down the road, attached to the lawsuit, Shazam is the certificate of loan, and that's Upstart signing again. And this guy, Sanjay Datta, signs everything from Upstart 6 days later. But the question is, and this is your linchpin, who gave it to Wilmington Savings Fund Society to give to Velocity? You'll never see it. So I've gone one step further than actually asking a court, where's this assignment, and having them look at me like a deer in the headlights and rule against me. I'm bringing in Upstart. I'm bringing in this Sanjay Datta, and I'm asking them to say, where's the assignment? If it was there, Velocity has gone against me enough, they would attach it to the lawsuit. I see it all the time. I do stuff against debt collectors and debt buyers. Eventually their complaints change. I've talked about that. And it doesn't make it harder, but they try to presuppose that I'm going to be on every lawsuit, and they change their complaint. Here, we never see the assignment when you have a bill of sale from somebody, and in this case, it's Cross River Bank. It's Cross River Bank and Upstart are big partners. I'm going to show you something. I'll try to show it to you now. It's ahead of my notes. But this is from Cross River Bank's own documents, in which they say, put up, starts with United States Securities and Exchange Commission, Cindy, and then you see what they say in their own paperwork at page 23 of this document, Form S2. Cross River Bank accounts for a substantial portion of a total number of loans facilitated by our platform. That's Upstart. Cross River Bank, or CRB, a New Jersey chartered community bank, in 2019 was originally responsible for 89% of our loans. And they make mention, too, of securitizing said loans. Excuse me. So that is a big partner with Upstart. So you get this Cross River loan. Upstart immediately takes over as a servicer, does all the securitization originating body for Cross River. You get a BS bill of sale that comes along trying to show that the securitized entity has now passed it on to Velocity without any proof. If they had it, it would be there. Trust me, if they put the other two things, and they're, as I showed you, the certificate of loan signed by Sanjay Datta on October 31st is 6 days after, meaning in that, let me put up the certificate of loan again, Cindy, Shazam. So that's Cross River Bank selling it to Upstart 6 days after the same debt supposedly was sold by Wilmington Savings Fund Society as trustee. First of all, as trustee of an alternate lending holders trust, that's a secured trust. Hello, we're telling you, you have to operate for a trustee. But who gave it to them, and why is it not easy to see that? And so you have to bring that out. And this third-party complaint approach to suing Upstart for this nonsense is a great way to go. So if they had any rights, meaning this Upstart, this Wilmington Trust, you'd see it, and you're gonna see it, but you put the onus and the burden on somebody else rather than you act from a defense. So my answer, counter affidavit, counterclaim are all on the website. They all say the same thing. Not me, no proof. I do discovery, and with the third-party complaint, I get to go talk to this Sanjay Datta or send him interrogatories and really put the pressure on them. I'm not doing it for that, but again, when you do a third-party practice, you're saying, Velocity, you have no right to sue me, or you're in partners in bed with this party you did not name with you. It's clear that Upstart, if you look at the certificate of loan that was signed 6 days after the bill of sale, Cross River can't give anything to Upstart that it doesn't already own. But if the trust is sending it to Velocity, the plaintiff in this case, either Cross River doesn't have a right to sell something, or somebody's lying 6 days early, I won't say who. So until you have proof that Cross River sent the debt to this trust, the trust can't give it to Velocity, which is the only link to Velocity to show it has a right to sue you. So I'm bringing everybody into the party. It's a third party, baby. That's what's happening. It's the one party this is the one party they wish they didn't get an invitation to. So that's good for you. In the third party that I wrote, a third party lawsuit against Upstart and this Wilmington Trust, I sued them under the FDCPA and the state's collection statute. And I also sued them for fraudulent misrepresentation. As a result of them creating a bill of sale without any proof and claiming they sold something to Velocity, and also signing off on something 6 days later that can't be legally, substantially, technically, or physically possible for Cross River. And they have full knowledge because they're signing both to sell something to Upstart if the same thing was sold 5 days earlier. So it's, oh, what tangle webs we weave when we practice to deceive. Oh, what tangle webs we weave when I third-party practice your in and explain why you're not telling the truth. You fraudulently misrepresented something so bad that Velocity believes it has the right to sue you. As a result of Upstart and Wilmington's bad actions, I'm getting sued, and my damages, I gotta hire an attorney and do all this work now, and I could get a judgment against me on false documents. And again, Velocity won't ever say, well, let me take a look at those documents. They'll go, sorry, Upstart created them. We don't have a duty. They do, because they're relying on it to say anything about these documents. So that's how you get them when you hear that they don't have to talk about documents that they're relying upon. So bring these guys in. You do it for several reasons, but you bring out that there's some sort of scheme going on here. I recommend you read, and I'll attach it to the video. I'm just going to read it. FinTech and banks, it's a strategic partnership that circumvents state usury laws by two people, Ellie Howson and Hannon. I'll attach this to the video. It's good reading. Web bank is prevalent in there, but it'll show you what's going on. As I said, there's securitization documents have to be filed in the form of S1 by Upstart, saying exactly what they're doing, which I've known all along, but a lot of times people don't want to listen. I recommend highly that you use this third-party practice technique. It'll probably settle your case. It's a little bit of work, but I've done most of the work for you as always. That's why I do these videos. You'll see all the templates attached to the membership video. Again, I'll have the answer, the counterclaim, affirmative defenses, the third-party practice that this is all about, and I'll throw in the counter affidavit along with my show notes. Yay! That way you don't have to look at this face again if you don't want to, and hopefully that explains things better than I have done. And also there'll be that FinTech writing that'll explain how the FinTech explosion is just hitting America hard, in that the debt buyers are getting hit worse than the debtors. They really are, because there's no way to show a real good chain of title from the original creditor to the Velocity, whoever's suing for Cross River Bank or FinWise or any of these banks. And they just have to hope that the judge lets them go their way. So you'll see in your argument against you Judge, he paid, he owes, but that's got nothing to do with ownership. That's another video. So thank you. I hope I've opened a door here for you. The documents attached will help you too. Like, love, and subscribe. Check out the membership website. All the documents you need attached to over 250 videos are there for you to do any case. If I've missed a case, I probably have, or a situation, let me know and I'll do that video. You can see a lot of my videos are from someone going, hey, how do I do this? Ask me and I'll do the video for you and give you the documents, all right? Hope this helps. Thanks a lot, Brian Parker.